Hello everyone. Hope I'm audible. If
Yes,
I'm
go
audible,
ahead.
just give me a thumbs up. All right. So, welcome back to the second day of our workshop on intellectual property rights in India, emerging trends. So, yesterday we had an enlightening session exploring the foundational aspects and recent developments in IPR. And today we'll build on that knowledge and delve deeper as we see the intricacies of the TRIPS agreements and other international facets. So, for those joining us today, we are once again privileged to have with us Ms. Shivani Gupta, ma'am, a gold medalist in LLM, intellectual property law, and a dedicated faculty member at KGK PG College in Muradabad. So, as we continue our journey through the complexities, let's make most of this opportunity to learn, discuss, and collaborate. Without further ado, I welcome back Ms. Shivani Gupta, ma'am, to lead us through today's session. And I request everyone to keep their mics and cameras muted and off. And those who filled the feedback form yesterday, they don't have to fill it again. And those who forgot, of course, they'll have to do it again. So just do it once, and we shall continue now. Everyone, Ms. Shivani Gupta, ma'am. Over to you, ma'am.
Good evening, Legal Vidya. Good evening, everyone present over here. Myself, Shivani Gupta. So, in the continuance of the tomorrow yesterday's session, we would like to continue with the remaining aspects of the intellectual property rights. The workshop concerned about what are the different intellectual property rights, what are the specific domains comprising the Copyright Act, Trademark Act, Patent Act, Plant Variety Act, Plant Variety Protection Act, Farmers Act, and so on. And then the today's session, we will discuss somehow about the trips also and somehow about the WTO agreements also. Now, as we have discussed earlier, what's the study and the objectives and the plan of the presentation already discussed earlier. Now we will move forward to the what we are going to discuss today itself. After the session completes, some of your participants are requested me to share this PPT. I will share you as the today's session get over. Then I will share this PPT to the legal vidya. Then they will share video. So yesterday we didn't discuss about the trademarks. We have discussed already. Collective marks discussed already. Now the geographical indication we will continue with because geographical indications were remaining in the yesterday's session. Geographical indications is also a kind of intellectual property. Geographical indication is comprising of the two terms particularly. The first term that deals with the geography, the particular word geography, and the second term that deals with the indication. Means that any kind of a good or agriculture good, any kind of a manufacturing good, any kind of a natural resource that are being originally originated in that particular geographical area that are being manufactured in particular geographical area. Geographical area is here in the law when we discuss about the GI. It's about the particular territory, particular country, or the particular locality. Because when we discuss about the legal protection of the geographical indication or the GI tag, we can say we discuss it under the aspect of the intellectual property. And yesterday we already discussed that the geographical indications or any kind of intellectual property is a territorial law. Means any of the country, any of the sovereign can make their law within their region, within their geographical limits. So, geographical indication is a kind of a goods manufactured good or naturally we can say naturally grown up goods or the in the any territory of the country, any region, any locality. And those goods that are being either manufactured or either originating naturally, that gives a special reputation, a kind of a characteristics they are exhibiting that are being based on the geographical origin of that good. So those are type of the goods are considered and to be protected under the geographical indications. Now, for example, I have mentioned the two names. That is first the Alfonso, that is a variety of a mango, and second I have mentioned the Basmati, that is a variety of a rice. Now there is a controversy about the Basmati rice because the technology, the technique that is being used in the production of the basmati rice crop is being patented by the other countries also, like the US patented it with the name Taxmati and on. So the geographical indications doesn't mean that the technology specifically being used for the production of particular aspect. It also includes here the goods also include the handicraft or handy industry that is being manufactured or being originated originally naturally there only. Under the geographical indications as the IPR category, the in India GI tags are being registered. There is a office under the IP government office geographical indications registry is there. They examines and publishes the application before the registration, and the registration for the GI under the intellectual property aspect is valid up to the 10 years, and it can be renewed indefinitely. For example, Kolhapuri sleepers are also getting the GI tag. So, no, oranges of the Nagpur are another example getting the GI tag. There is a one variety breed of the that cock also, that is the Kadaknath, that also get GI tag. So there are specific varieties in the form of a goods, in the form of a particular breed, and like that, those get the protection. Now, if any of the goods that get the protection under the GI, they exclusively get the right to use the GI on the goods, and they also obtain, the persons also obtain any kind of a relief for the infringement of those GI. Now comes the another category, that is the semiconductor integrated circuits and layout designs. This is another category under the intellectual property rights only. Now, under intellectual property rights, along with the copyright, patent, and the trademarks, other protectable layout designs are also there. Those designs include the originality, the novelty. Now, the originality and the novelty is the basic aspect that deals when it comes to the every aspect of the intellectual property rights. In the case of the patent, also in the case of the trademark, also there is kind of a thing that in the case of the copyright, also there is a kind of a thing that the originality must be there. So in the case of a layout designs of any kind of a semiconductor, any kind of a integrated circuit, so one can get the protection under the intellectual property rights protection laws through the registration process. Registration procedure can be followed by either with the help of any IP attorney or any of the IP agent. Now, the protectable layout designs are protected once the registration being made, then the application being forwarded for the examination, and for up to when the registration once made, application once approved, there is no as such grievance is there, there is no as such an objection certificate is there, then the registration completed, and that's valid up to the 10 years. Now, what happens when there are certain layout designs, those are not being registrable. So, the no not being registrable includes the category. I have compiled upon the screen the categories that including the non-registrable layout designs. The first of all, the layout designs, those are not original. The layout designs that has been commercially exploited in India, even in across the globe, not inherently distinctive, not inherently capable of being distinguishable from any other registered layout. So there is a criteria, like we have discussed in the yesterday's session about the patent. Also, there is a criteria for the novelty criteria to get the object or the service or any kind of a good or any kind of a invention and innovation patentable. So there is a criteria of novelty and originality. Same in the case of a layout design also. There is a criteria of the originality of to save them from being commercially exploited, to save them from the inherently distinctive. So there is a criteria for the layout designs also. Now comes the another aspect, that is the trade secret. Trade secret means what? We have already discussed most of the aspects under the Trademark Act, under the Copyright Act, Patent Act, Layout Design. But now there are just things like, now we can't execute them into the physical form. But they are just like the ideas, they are just like the inventions, they are just they are just like the survey methods, manufacturing processes. They are just like the experimenting results, chemical formula, or we can say any kind of a data, any kind of a information. So if any kind of information or data is there and you want to protect, and that data information is not being falling under the ambit of any of the IPR, including copyright, patent, trademark, layout, design, and so on. So, but that information need to be protected. And what's the criteria would be followed for them? So, regarding that, there is another kind of IP category being made, and the protection being given as per the law, that is regarded as the trade secrets, especially mentioned upon the slide. I am just reading the slide, and you can be better acquainted with what I'm trying to say. What the trade secret is. Trade secret can be any invention, idea, either the survey method, manufacturing processes, experiment results, chemical formula, recipes, financial strategy, client data, and so on. But those kind of inventions, those kind of a data, those kind of informations that can't be protected under any or that are not falling in the ambit of any of the existing intellectual property laws. So these informations are held as confidential. These informations are being protected, and those are being protected under the trade secrets. Now, the thing comes into the mind when their trade secrets are being preferred. If the inventions are in the category that they are not patentable, then we refer the as the IP attorney or as an IP agent, we refer that the client to get the invention. If it is not patentable, then get the trade secret protection over the same. Now, patent protection is also somehow limited to 20 years, and get renewal is done, but it takes a long way process to get the renewal. But it's so when the secret can be kept beyond that period, then also we prefer the trade secret. If we want to prohibit the patent protection or that idea we want to protect it because that is costly enough, then also we prefer the trade secret. When it's difficult to reverse the engineers, then also the trade secrets are being preferred. There are some criteria also to guard the trade secrets, and the criteria, first criteria is the providing a national legislation. The only and the utmost effective criteria is the same. Next criteria, we can be take it like restricting the number of people having the access to the secret information. Those are signing confidentiality agreements with the business partners and the employees. Like using the protective techniques like the digital data security tools and the restricting data entry into the any trade secret where worked or held. So there are some aspects where the trade secrets are being they are being protected, and it covers the in the holistic form all aspects of the intellectual property. Now comes the very important and the last aspect, that is the plant varieties and the farmers right. Now when we discuss about the protection of the plant variety, then the three aspects come. What is the criteria, registration criteria, are the varieties new varieties only registered, are the extant varieties are also registered, the who are the persons eligible to register, and what is the period of the protection will be provided. When comes to the protection of the plant varieties, registrable varieties, and their criteria, followed by two aspects. The first aspect is the new variety. New variety including the distinctiveness, novelty, uniformity, and the stability. Next is the extant variety that includes the uniformity, stability, distinctiveness. The person who can register under the plant variety protection are the breeders, any of the farmers, university, agricultural institutes, and research institutes, etc. Period of protection, either for the annual crops it's 15 years, and for the trees and the vines it's the 80 years, and it can be extended also. Now I have used the term that what are the persons eligible to get the protection under the Plant Variety Protection and the Farmer Right Act. So there is a kind of a breeder also person who is eligible. There are certain rights of the breeders also. Their rights is for the production. Their rights are for the sale, either for the marketing, its distribution, export, and import. There is a particular category I have compiled. These are all the rights that are being adhered with the rights of the breeders. Now comes there is another person who is eligible, that is the farmer. So to save, use, sow, resow, exchange, share, or sell his farm produce, including the seeds, in the same manner as he was entitled earlier. So here the seeds that are for the sale should not be branded. This is the criteria being mentioned under the law also. Now to the full disclosure of the expected performance of the seeds or the planting material by the plant breeders, where there is a scale to perform in the manner either claimed by any of the breeder. The farmer may claim the compensation from the plant breeder also, and this aspect is being mentioned under the law. Another aspect is that another person who is also eligible to have the rights to get the protection under the plant variety protection, that is a researcher. So researcher also having some adhered right to himself. That rights includes free and the complete access to the protected material for the research use in developing the new plant varieties or to developing the new hybrid varieties. Another is the authorization of the breeder is required, whose repeated use of such variety are parental line, as those are necessary for the commercial production also. So the researcher rights are also included there. Now that's all we have discussed till now. Till the time 516 is about the different intellectual property aspects. Now comes the today's session aspect, that is the international organization. So the international organizations that we gonna discuss today is about two organizations are there. I have mentioned, that is the WIPO and the World Trade Organization. So first of all, I would like to discuss about the World Trade Organization. The first thing, the World Trade Organization is abbreviated as the WTO also. And WTO is the only global international organization that is dealing with the rules of the trade between the different nations across the globe. Now, at its heart are the WTO agreements, are there negotiated and signed by the bulk of the world's trading nations and ratified in their parliament. So on there is a update also about that on the 15th of the February 2021, there was a WTO director that was appointed. First women director was appointed, and that was she was the first women chief of the WTO and first African lady to hold as the director general. That is the Ngozi Okonjo. Now comes what are the latest updates. We follow the World Intellectual Property World Intellectual Property Organization. So WTO is a there are certain other international organizations also that somehow deals with different aspects of the intellectual property rights in their day to day meetings. But the WTO is the only international organization till now who is dealing. When we discuss about the WTO, we discuss it in a several ways, because the WTO itself is the organization that is responsible for the liberalizing trade. That is a forum to negotiate trade agreements for the various governments. WTO is the only place that where the trade related disputes are being settled. So it operates as a system of the trade rules also. WTO is we can say one of the most important feature that is that it's a forum where results came after the serious negotiation. Essentially, WTO is a particular place where governments whose members go in order just to sort out the trade problems as they face with each other. The first step is to talk, then the WTO was born out of the negotiations. Everything the WTO does is the result of the negotiations itself. The bulk of the WTO's current work comes from the in 1986 to the 1994 negotiations that we call the Uruguay negotiation. The word we can say when we discuss about the functions history we can, in the history aspect of the WTO, we can say when the GATT was mostly dealing with the trade in the goods. What happened? Okay. The GATT mostly deals with the trade in the goods. The WTO and its agreement couldn't only cover the goods but also trades in the services and the other intellectual properties like the trade creations, designs, and the inventions. When it comes to the functions of the WTO, then there is a category of the functions. The WTO's overriding objective is only just to help the trade flow smoothly, fairly, freely, and predictably. Now, it does by the administering the WTO agreements, conducting forums. Uh, for the trade and negotiations, handling trade disputes, monitoring the national trade policies, providing the technical assistance and the training for the developing countries, cooperation with the other international organizations also. Now there are the ministerial conferences also of the WTO. Then those ministerial conferences includes either MCI that place is the Singapore where it was held in the year 1996, and it's the uh, and other places is also Nairobi, Kenya, where the 2015 it was declared. Now the Doha Declaration was the one in November 2001 that come out of the fourth ministerial of the WTO that took place in Doha, Qatar, and the declaration also gives the mandate for the negotiations on any of the array of the topics that including issues concerning the implementation of the previous agreement. So that's all about the WTO. Now comes the very important aspect, that is the IPR licensing and the technology transfer. And in the next few minutes, we're gonna discuss upon the same. Licensing of the IP is a very important aspect, and every law student might be just like want to know that what is market licensing. First of all, see, licensing means what? Licensing is the economic aspect. When we discuss about the economic aspect of the law or the intellectual property right, then licensing is the category that we comes in the mind to that comes in the mind. Licensing means what? Licensing is granting the permission, and the permission is granted by the person. The person You all can fill the feedback form, but just listen to what I'm trying to say rather than focusing upon the feedback form only. You will definitely receive the certificate once you
Ma'am,
fill the
I
feedback form.
request you to please ignore them. I'll answer them. Thank you.
Oh, okay. Because these messages are flashing again and again. Okay. Now the licensing is a kind of a permission that are being granted by an IP owner, and IP owner included what? Any of the person who is just the copyright holder, who is the owner of the any of the copyrighted work, any of the patent holding person, or any of the person, and that owner or that person allows another person to use the registered IP on the particular terms on which the conditions on which a contract being made, and then the person itself who is the main principal owner will retain the ownership of the intellectual property right. Now another thing, the licensing also devised as creating an income source which particularly establish, as I have mentioned, a legal framework for the transfer of the technology to the wider group of the researchers and the engineers. Licensing of the IP make a market presence for the technology and the trademark. Licensing is the only aspect by which the ownership doesn't get distinguished, doesn't get spoiled, doesn't get influenced, and under the specific terms and the conditions, the owner of any of the intellectual property they can just allow another person on the certain agreed terms and the conditions. Now there are certain conditions for the licensing of the IPR. First of all, they are in the ambit of the law. They are either in the ambit of the law, either in the case of a competition law, either in the case of a intellectual property law, comprising the different domains. First of all, the owners of the intellectual property prefer to transfer the technology through the licensing agreements. Only licensing agreements make the deal secure full-fledged, because there are certain limitations, certain rights that are being granted through the licensing. And those licenses can be either the exclusive and the non-exclusive or the sole. Is those all the such agreements also provide for the royalty payments also, and there is a condition for the non-transfer to the third party. So that is the aspect that are being specified or protected by the licensing. Licensing condition is just protecting the IPR it's like a double security. being given. First, your work is all original work is being protected under the different domain of IPR. Then IP law, and then it's being protected. Once the under protected under the IP law, it's protected again under the licensing conditions. The royalties or can be upfront. There can be part front also. There depends upon the economic ratios and profit and loss values, production sale ratio. Particular uses for which the IP can be used are generally specified. Either they are the copyrighted material, either they are the patented work, either they are the trademark work, and so on. They are also protected under the Competition Act, as I have mentioned earlier. Now, the question comes in mind, and I have mentioned or compiled some of the data that I said did the licensing is profitable or not. Yes, licensing is obviously profitable. As you can say, many of the companies across the globe have making the a full-fledged amount of the profit through the licensing. For example, IBM revenues that from the patent licensing is $1.7 billion. Then the year 2002, and in the year because SS NOS's latest report is available, but through the research we find out this much data only. Either it's the Texas Instrument that also generated the billions of the profit. Then US and Canadian universities also generating the royalty. New York University is generating the royalty. OU University and CSIF. So they are also generating the royalty and making milestone payments. There is a criteria. Licensing, obviously a profitable thing just to put forward for the technology transfer, either for the protection of the IP. And that's all about the different licensing and the data protection techniques under the IP. And now please start putting your queries for the same. Because it's not a one-way conversation, so you one by one either unmute yourself or I would like to take each and everybody's query regarding the intellectual property rights.
Those who wish to speak, they can raise their hands, and the rest can surely put their questions in the chat box. Thank you. Sure.
Yes, please ask your question. But
I guess, ma'am, it was so clear and it was just phenomenal the way you took this whole workshop that they literally don't have any doubt. And thank you, ma'am. It was really, really amazing. And now I would request our founder, Miss Sakshi Sharma, ma'am, to deliver the vote of thanks. Over to you, ma'am.
Thank you so much, Vaibhav. Am I audible?
Yes, ma'am, you are.
Great, thank you. Good afternoon, good evening, Shivani ma'am. I hope you're doing well. And ma'am, I'd like to thank you on behalf of the team of Legal Vidya and all the participants who are here to take such a wonderful workshop for these 2 days on IPR laws. It was definitely very interesting to learn about various kinds of intellectual properties and the laws relating to them. And you have explained everything in great detail, ma'am. And you have also answered the queries that some of the participants had yesterday. So, ma'am, thank you so much. And we look forward to having further collaborations with you. It was a great session, ma'am.
sure.
Thank you, ma'am. And also,
There is question also. Oh yeah, thank you.
thank you, Vaibhav, for hosting the session, and to all the participants who have taken out their time to join the session. It really means a lot to us. Thank you, ma'am, and I wish you all a very happy
Thank
weekend.
you.
Have a good day. Thank you, ma'am.
Thank you.
Thank you so much, everyone, for joining. And the workshop is over now. Thank you.